Please, Your Lordship, with regards to the hearing column item number 12, Your Lordship, we have seen the record, and it seems that the info, even though notice has already been completed, there is no legal aid to represent
No,
the
no
informant.
legal aid counsel was appointed.
Yes, ma'am.
Let's have a look. Item number 12.
Otherwise, we are ready.
Learned amicus curiae is the matter for hearing. Yes, amicus.
My
Okay.
learned-
Yes. Mr. T. Lalzakima, learned amicus curiae is present along with Mrs. Mary Kiamte, learned additional public prosecutor for the state respondent. It has been brought to the notice of this court that though notice was duly served to respondent number 2, none appeared on behalf of respondent number 2, and no legal aid counsel has been appointed to represent respondent number 2. In view of the above, we find it fit to appoint, yes, Lalrokunga Pautu as legal aid counsel to represent respondent number 2. Stop. Then requisite copies of the paper book to be duly furnished to the learned legal aid counsel. List after 1 week.
My lord.
May I seek your lordship indulgence on mentioning item number 13? My lord,
1-3.
13.
1-3. Oh.
Yes, ma'am.
Mhm.
My lord,
What happened?
my senior is out of station. I could not appear.
Okay. No, will it not?
13, my lord.
Yes. Mention is
senior-
made on behalf of Mr. Lalpian Fella,
Yes, my lord.
learned counsel for the appellant for adjournment of the matter since the learned counsel is said to be out of station. In view of the above? Okay, then out of station, then Mr. Rokung Apautu, learned legal aid counsel for respondent number 2, and Mrs. Mary Kianke, learned additional PP for the state respondents are present and have not objected to the adjournment of the matter. In view of the above, list after
Next week.
1 week.
Yes, my lord.
Admission, item 1. My lord, in this case, I seek another 2 weeks time, my lord. Unfortunately, the information that was sought has not been furnished till date from the petitioner. And apart from that, my lord, the conditions of the road at this stage is nowhere near satisfactory.
Okay, so you file an affidavit with photographs, isn't it?
Yes, my lord.
Here,
that
in
is
the
intent.
last court date, you had also mentioned that there's a notification wherein 59 crores
Yes, my lord.
have been allotted.
Yes,
So that also we have to see, because the government advocate, they don't know about this, it appears, isn't it? Yes. Heard Mr. Rupu Napapu, learned counsel for the petition, who has prayed for further time to file the affidavit in compliance with this court's order dated 21/05/2025. In view of the above, list after 3 weeks.
My lord. I'm obliged. Item 2.
My lord, in this matter, I'm appearing for the respondent number 1, sole private respondent, my lord. And my lord, on the last court date, I was directed to file affidavit. And my lord, however, the signatory, the deponent of this affidavit is presently having some personal difficulties, my lord. We'll be able to file within 2 days, my lord.
Okay. Mr. H. Zodin Sala, learned counsel for the respondent number 1 has prayed for further time to file the additional counter affidavit. In view of the above, list after 3 weeks.
Yes, ma'am. Item 3.
Yes,
Your Lordship, we have
there are
filed.
two respondents, respondent
affidavit
number 1 and
notices.
2.
Yes.
You're definitely representing respondent number 1, but
Yes.
what about 2? Are you representing respondent number
No.
2 also?
No.
No. Then notice not complete upon respondent number 2?
Notice, my lord, it was AD card was, my lord, sent way back in February, my lord. So in that regard, lordship,
Steps not taken. See, it appears you take a fresh steps upon respondent number 2. Let's see.
if my lord, respondent number 2 may kindly be taken as a deemed served notice, my lord.
No.
In terms of section 27 of general closing circulars.
Oh, what does it say? 87?
When any duly addressed notice is sent, my lord, and unless the contrary is proved, my lord, it may also be taken as deemed served.
No, we, it's a little bit risky, simply,
Actually, my lord,
because there has to be some.
we have
distance,
sent the copy of all these notice to the same address that was used in the writ petition, my lord. In the writ petition also, they appeared and were represented by counsel, my lord.
Oh.
So in that very same address, we sent
But
again.
could they have changed their address?
That information, my lord, that
you
is
have
not
to do your homework, no?
known to me, my lord.
Simply presuming.
No, near
You
permanent-
issue fresh notice, then we will ask the registry to track the consignment after that. Isn't it? Because now it's sometime, time has lapsed, so.
Actually, that is why, my lord,
Then
in
you
that circumstance, as your lordship knows well, we used to take it as a deemed served, my lord.
We'll track the consignment after that. You take
Because-
fresh steps first, okay? Then if it's not returned,
It's been
no
long
response is
back,
there,
my
then we will track the consignment, because I think the respondent number 2 is a necessary party here. We can't decide without their presence.
I agree.
It's concerning something where they have to be present. Yes, Mr. C. Zoram Chana, learned counsel for the applicant / appellants is present. No, but this is IA is for condonation of delay, isn't it?
IA is only for condonation of delay of
how many
26
days?
days. 26 days, your lordship.
I think we can, are you going to file a written objection?
We have already.
They have filed it, my lord.
File. We can consider the condonation matter, and then the main appeal.
Yes,
fresh
yes,
notice
definitely,
be
I do,
issued.
madam.
Then
I'll
we
do
can
mine.
see. 47 days, huh? Let's see what is the reason.
It's actually 26 days, and along with the winter vacation, it comes up to 57 lots. But without that
57
winter
days,
vacation, it is the actual delay caused by the applicant is 26 days.
But winter vacation registry is always open. Anyways,
Yes. The my petition read as herein, and then the case is regarding, my lord, alleged deduction of 5,79,376 rupees from the provident fund account of the present respondent number 1, my lord, by the present applicant, my lord. And the learned lower court, my lord, White order 18 dated 18/10/2024 in WPC number 116 of 23 was pleased to pass the impugned order directing the present applicant, my lord, to refund back the deducted amount. So being aggrieved, lordship, I have come before Lordship, and my line of my Lord pleadings are herein at para number 3 down below my Lord. The copy of impugned judgment and order dated 1810 was obtained from website on 25 10 2024. It is what uploaded on that date only, my Lord. And then thereafter, the same was furnished to General Manager of MRB in the head office of MRB, seeking for advice on 2810 as 26 and 7 falls on holidays, Saturday and Sunday. So the General Manager of MRB, my Lord, forwarded the same for decision to the chairman on 3010 for taking decision as to whether an appeal would be preferred against the said order. The chairman returned from her tour on 4th of November, and the file was put up to her table on 6th, my Lord. And she called a meeting on 12th, my Lord. And the issue was taken up, my Lord. The meeting held on 12th took a decision to challenge the impugned order dated 18/10/2024 as no forfeiture of provident fund belonging to the present respondent lordship was done, and to be for an appeal was also intimated to the council, my Lord. Verbally, it was conveyed to the standing council on 14/11, lordship, and he was instructed to proceed on with drafting of the memo of appeal. And in the meantime, the statutory period of 30 days had already lapsed on 17 November 2024 before drafting could be completed, man. So thereafter, the council began drafting the memo of appeal along with connected applications for condition of delays, man. And after the council collected the materials and worked on the drafting, and the memo of appeal was ready to be filed on 29th of November 2024, lordship. And thereafter, certified copy of the judgment was not obtained and applied for on 3rd of December, lordship. And the same was applied to the present applicant on 6th of December, lordship. And then the compilation was done thereafter, my lord. And then it was completed on 13th December, my lord. And till that date, my lord, a delay of 26 days was occurred, had been caused, my lord. However, since the winter vacation started from 14, my lord, so it till 12th of January next month.
But during the vacation, isn't the registry open? Someone is always there, I think.
That to my knowledge, at that time, my lord, was not open.
No.
Maybe not informed to the knowledge, my lord.
There's always someone on duty. The registry is never completely closed. Anyways, yes.
My lord. That, and then it was filed on the very next day when it reopened on 13th of January, my lord, 2025. So altogether, a total days of 57 days was caused in filing the connected appeal, my lord, writ appeal. Actually, as I submitted earlier, the actual delay caused by the applicant was only 26 days, my lord. So that may kindly be condoned, as there was no inordinate delay, my lord. There was no
Yes, okay.
willful
yes.
delay, my lord.
Yes.
So it's only, and for that, my lord, if I may rely on, since the MRB, my lord, is having a government-like setup, organizational setup, there needs to be some consideration has to be taken, like the one person cannot take a decision, my lord. Decision for to be taken has to go through a great number of tables, and ultimately a board has to decide it, my lord. And for that, and even after that, my lord, decisions taken by the board also has to be conveyed through proper channel. For that, my lord, it functions like a government. For that, my lord, if I may take a lordship to one citation, 1996, volume 10, SCC 634. This is a very short judgment, ma'am.
Where is it?
Paragraph number 2, ma'am. there might be some lapses, some days which are not explained. Day-to-day explanation might not be there. But as far as possible, it is done. For that, my lord, para 2 says of this judgment, it is now settled law that when the delay was occasioned at the behest of the government, it would be very difficult to explain the day-to-day delay. Transactions of the business of the government was being done leisurely by officers who had no or evince no personal interest at different levels. No one takes personal responsibility in processing the matters expeditiously. As a matter, at several stages, they take their own time to reach a decision. Even in spite of pointing at the delay, they do not take expeditious actions for ultimate decision in filing the appeal. So now, same applies here in my present case also. Since it is not a private case, a private matter, so delay is caused due to some lapses, my lord, on the part of the staff also. Now, if I may again take to your lordship to Lipok our case, my lord, that I think your lordship knows very well, Lipok our. So I'd also refer and rely on para 8, 9, and 15 of
What
that.
is the citation? The Lipok case, Lipok or whatever?
Lipok 2005, volume 3, SGC, lordship. 752.
752.
My lord, here also, the same is the case with therein, my lord. Para 8, 9, and 15, my lord. So now, since there is no such a big delay, my lord, there is no inordinate delay, only 26 days of delay caused, my lord. So it may kindly be condoned, my lord. And otherwise, there will be, justice won't be carried out, my lord, in the present.
Yes, okay. Yes.
Your Lordship, I have given my Paraguay's comment in my affidavit in opposition. What I would like to mention here is that the reason for delay cited by the applicant, such as internal meetings, chairman's tour, etc., they are administrative matters only and do not justify such substantial delay in the matter involving the rights of the respondent. The applicant has failed to demonstrate any due diligence in pursuing the appeal. What I'd like to mention is that lack of proper administrative coordination or departmental delay is not sufficient ground for condoning of delay. And moreover, Your Honor, Your Lordships, the application itself lacks bona fide, as the main issue of the case has already been decided by Honorable Judge of a single bench of this court. The judgment the order dated 18/10/2024, confirmed that there is a clear statutory bar on forfeiture of contributory provident fund, and decided that the action of the applicant bank was against the law. So, Your Lordships, therefore, the instant application lacks merit, and it is, according to me, in my humble opinion, fits to be dismissed outright. So the rest, Paraguay's, my opposition has been clearly cited in my affidavit in opposition.
Okay. Yes. Coordination is allowed. We'll pass the order later.
Obliged.
Okay. And now, in the main, considering the number of days and then the reasons, your reason which has been given by me, we find it that appropriate steps have been taken by you. And though this period of vacation, we'll have to verify
Actually, yes, my lord, that might
But
be
since
mistake on our
you-
part also, my lord.
maybe, but since the court was not functioning, we'll accept that explanation given.
Right.
Okay. Now, in the main writ appeal, on the disposal of, on the disposal of IA 2/2025, allowing the condonation of delay. This court find it also wherein condonation application is allowed, okay, instead of contingent delay. I heard Mr. C. Zoram Chana, learned counsel for the appellant, who submits that there are sufficient grounds for filing the instant appeal against the judgment and order of a single bench of this court in WPC number 116 of 2023, dated 18/10/2024, since the learned single judge had not appreciated the facts and circumstances of the case in its proper perspective. Appeal is admitted. Issue notice to the respondents. Mr. Chongpo accepts notice on behalf of respondent number 1. Notice be issued to respondent number 2 through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Deeply obliged.
For this, item 5.
Yes,
Lordship, I am appearing on behalf of the state respondents. State respondents will not be filing any written objection with regards to the item.
how many days? Condonation is? I is for condonation, isn't it?
Yes, my lord.
3 days. Oh,
Then if the state government will not be filing, my lord, the matter may be listed next available bench.
okay. Heard, Ms. Zairam Sangpui, not prepared today. Learned CGC. Who has prayed for adjournment of the matter? It was Mrs. Caroline Keelan Moipui, learned government advocate for the state respondents, submits that the state respondents will not be filing their written objection. The presence of Mr. L.H. Yanshima, learned senior counsel, is noted. In view of the prayer made by the learned CGC, list the matter after 2 weeks.
Next available bench, my lord.
After 2 weeks,
Yes,
2
ma'am.
weeks, the bench will be available. Let's see, it's okay with the matter. Okay, because they are not filing the written objection also.
But then tussle is between the union and the state.
So, the state, they will not be filing any objection also.
Item 8. Lord,
Oh, yes.
My lord, I am appearing to VC, my lord. I am praying for some more time to take steps, my lord. Due to some miscommunication, my lord, the order, the steps could not be taken, my lord.
Okay. Heard Mr. H. Gupta, learned counsel for the applicant who has appeared through VC. The learned counsel for the applicant has prayed for further time to take steps upon the respondents for issuance of notice.
For paper publication.
True paper, newspaper publication.
My
In view of the above,
lord.
list after maybe 4 weeks, and the date of
4 weeks.
appearance. Okay, give me the date of appearance. The date of appearance
Lord,
to be
after-
mentioned in the notice is after 4 weeks, huh? So give me a date after 4 weeks.
My lord, may
1, 2, 3, 4.
still
Okay. Let's make it 10th September. 10th September. Okay.
my lord,
Date of
my lord,
appearance to be mentioned in the notice would be 10th September.
my lord.
2025.
Item
Public.
9.
So this is the first history, and there is a delay of 135 days. And I seek lordship to issue notice to the respondents for the delay in filing the appeal. There is a delay of 135 days. This is the first.
Wait. Okay. Date of the judgment order is 020/2025.
Date of filing is 22/7/2025.
In what? You have not mentioned that in your cost title. Make it clear, isn't it?
Yes,
Just
it
the
is.
judgment order, but in what? Writ petition
Writ
what?
petition number 75 of 2019.
So you see, in
It-
your
it- it is
cost
in
list,
page
on the
number-
first, when you look at page 1,
Page 2.
okay, yes, page 1
Page
and 2, and 76, is it? Huh.
Yes, this is the
Okay.
common judgment and order.
Heard Mr. Roshan Subedi, learned counsel for the applicant / appellant, who has filed the instant application under Section 5 of the Limitation Act, 1963, praying for condonation of delay of 135 days in filing the appeal against the common judgment and order dated 06/02/2025, passed by the learned single judge in WPC number 75/2019 and WPC number 76/2019. Full stop. Issue notice to the opposite party / respondents through registered post with AD within 3 days, returnable by 3 weeks. Yes, then full stop. Then Mr. Swamil Tangte accepts notice on behalf.
Respondent number 460.
You
to
are
462.
appearing on behalf of the
State
government?
respondents.
State, okay. Learned additional AG accepts notice on behalf of the state respondents number
460 to 462.
462, 462.
Yes, ma'am.
While Ms. Yes, Zaram Sangpui, learned CGC accepts notice on behalf of Union of India respondents number
463.
463. Yes, full stop. No need to issue a formal notice to the state councils. Requisite copy of the IE to be duly furnished to the learned councils just after 3 weeks.
Lordship, one prayer. There are 459 respondents. These are all the landowners. So I may be, because these are very bulky documents, so I may be allowed to take a substituted way of service, because by registered AD to 459,
But where they all, this thing, what is the address?
address is in Lunglei district, all from Mauzam village. Same village,
Lunglei district.
yes, all from one locality,
Saisen.
Uh-huh.
same locality, some are
Then-
Bandia Sora. These are closely related, size and etc. These are very closely situated villages.
So do they have a, okay, then I think a local, this thing,
Newspaper.
newspaper, at least one of them should be able to,
Yes, yes.
isn't it?
It's really
Oh. But some of them are from,
Yes, some of them are from
Mausam.
Bandiasora, some are from Saisen. These are very closely situated villages. So you can issue in one newspaper that will
Three districts.
serve the purpose.
but how can we ensure that?
Takes steps. Otherwise, if not
Notice has
possible,
been
then we
duly
will take
served.
another way of service again, by way of
No.
dusty or otherwise.
Probably of Dusty.
Because these are from the same villages, like closely situated villages.
I don't know, newspaper straight away, how can we ensure that they are even aware and all of them have been informed?
In that way, I may be allowed to take dusty steps. I will ensure that all of them receive.
Yes,
Dusty
okay.
steps.
Uh, oh, okay. Instead of issue notice, okay, the learned counsel for the applicant has prayed that, considering the fact that there are, how many numbers?
459.
459 private respondents, he may be allowed to serve notice upon all the respondents through dusty service instead of through registered post. We accordingly allow the learned counsel to serve notice upon the private respondents through dusty mode, affidavit to the effect to be duly filed by the next date, just after 4 weeks.
4 weeks.
4 weeks.
Item 10.
Item 10 is also similar.
Okay, same order.
Respondents will be different. In this, respondent 553 to 555 is the state respondents. 556 is the
Okay, same order.
Same order, different respondents.
So only thing is, state is respondent number
553 to 555, ma'am.
553 to
55.
555, while CGC is
556. And there are
556.
552 private
Okay,
respondents.
and 552 private respondents.
Item 11.
My lord, this IA is for application for condemnation of 321 days delay for filing written against judgment and order dated 13/8/2024, passed in WPC 96 of 2022.
Yes, Ahad Mizaram Sample, learned CGC, who submits that the instant application filed under Section 5 of the Indian Limitation Act, 1963, is for the condonation of a delay of 321 days in filing the appeal against the writ petition number 96 of 2022, passed by the learned single judge with 96 of 2022, dated 13/08/2024, passed by the learned single judge, Aizawl bench. Then issue notice to the respondents through registered post with AB within 3 days, returnable by 3 weeks, just after 3 weeks. Yes.
Offline.